We're about to get started. It's not on? Is this thing on? Okay, great. All right, good evening everyone, and thank you all for being here today. My name is Alfred Kalantar, one of the panel coordinators for this symposium. This evening's panel is called How We Got Here, the Supreme Court's Anti-Administrativist Turn. A lot has happened recently in the world of administrative law, and the field looks quite different than it once did. From Chevron to Inloper-Bright to the non-delegation and the major questions doctrines, this panel will explore the interplay between the Supreme Court and Congress in shaping the dynamics of modern administrative law and provide insight into where administrative law is headed and potential legal and policy reform directions. Our moderator for tonight's panel is the Honorable Chad Readler of the U.S. Court of Appeals for the Sixth Circuit. He sits in Columbus, Ohio, despite being a double Wolverine, having received both his BA and a JD from the University of Michigan, where he is also a lecturer and teaches a class on presidential powers. After graduating, he clerked for Judge Alan Norris on the Sixth Circuit and practiced law at Jones Day, where he spent 10 years as a partner, arguing cases before the Supreme Court of Ohio, the U.S. Court of Appeals for the Sixth Circuit, and the U.S. Supreme Court. Judge Readler served as Acting Assistant Attorney General for the Civil Division of the DOJ from 2017 to 2019, and was confirmed to serve as a judge on the Sixth Circuit in 2019. And now on to our panelists. Professor Jennifer Mascott graduated from the George Washington University Law School and is a former law clerk to then Judge Brett Kavanaugh on the D.C. Circuit and to Justice Clarence Thomas on the U.S. Supreme Court. After teaching at the Antonin Scalia Law School of George Mason University, she joined the faculty of Catholic University of America Columbus School of Law, where she serves as founding director of the Separation of Powers Institute. From 2019 through 2021, Professor Mascott served in the DOJ as a Deputy Assistant Attorney General in the Office of Legal Counsel and then as an Associate Deputy Attorney General. She has also been nominated by President Trump to be General Counsel of the U.S. Department of Education. She writes in the areas of administrative and constitutional law, theories of constitutional and statutory interpretation, and the constitutional structural separation of powers. Professor Nina Mendelson is the Joseph L. Sachs Collegiate Professor of Law at the University of Michigan. She received her JD from Yale University and clerked for Judge Pierre Laval on the Southern District of New York and for Judge John Walker Jr. on the Second Circuit. Before joining the Michigan Law faculty, Professor Mendelson served for several years as an attorney with the DOJ's Environment and Natural Resources Division. She teaches and conducts research in the areas of administrative law, environmental law, statutory interpretation, and the legislative process. Professor Thomas Merrill is the Charles Evans Hughes Professor of Law at Columbia Law School. He received his JD from the University of Chicago Law School and clerked for Chief Judge David Bazelon on the D.C. Circuit and for Justice Harry Blackmun on the U.S. Supreme Court. Professor Merrill was a Deputy Solicitor General of the DOJ and an associate at Sidley Austin, where he also served as counsel for more than 20 years. Some of his main areas of specialty include administrative law, legislation, public policy, and judicial review of agency action. General Aaron Nielson is a law professor at BYU Law who is on leave to serve as Solicitor General of Texas. Very nice. He received his JD from Harvard Law School and has an LLM from the University of Cambridge. He previously was a partner at Kirkland & Ellis and clerked for Judge Jerry Smith on the Fifth Circuit, Judge Janice Rogers Brown on the D.C. Circuit, and Justice Samuel Alito on the U.S. Supreme Court. Professor Jeffrey Pojanowski is the Biolchini Family Professor of Law at Notre Dame Law School, where he has served in the faculty since 2010. He received his JD from Harvard Law School, after which he clerked for then Judge John Roberts on the D.C. Circuit, and then for Justice Anthony Kennedy on the U.S. Supreme Court. Before joining the faculty of Notre Dame Law School, Professor Pojanowski practiced law with Latham & Watkins in Washington, D.C. His main areas of research are administrative law, general jurisprudence, legal interpretation, private law theory, and torts. There will be time for questions at the end, so please keep any questions you have in mind that may arise during the panel. And now I will turn over the floor to this evening's moderator, Judge Readler.
Great, thank you, Alfred. So those of you who are here for the last panel and were also here for the recording of the Advisory Opinions podcast will be disappointed to learn this is the first panel that Sarah Isger is not moderating. So you're stuck with me, but I think we're going to have a great discussion over the next hour and a half. Welcome everyone to Ann Arbor. So this is my alma mater. I took secure transactions in this room about 30 years ago. You're in the best college town in America. I'm going to say with judicial impartiality aside, you're at the best law school in America, and I think you're in store for a terrific weekend. So congratulations to the chapter here at Michigan Law School for putting on this event. This is a terrific event. You've done a wonderful, wonderful job, and we're all in store for a great weekend, as I mentioned. Thank you to Professor Walker specifically for putting together the curriculum for this weekend. And thank you to all the students for being here. There's not much of a hearty round of applause for yourselves. I feel like we should do it again. But look, there's a lot of things you could have been doing this weekend. You could certainly have been in a warmer place than Michigan in March. But you're all here, one, to learn, but two, I hope, sort of looking forward. You'll make great connections through this conference and through other programs. In 20 years, we'll be counting on all of you to be sitting up here and guiding us through the legal issues of the day. So congratulations on starting that journey. We look forward to seeing your success in the coming years. So our topic today is administrative law and the Supreme Court. We're going to sort of survey recent decisions from the Supreme Court, some issues that have been resolved to some extent, some issues that are currently pending. It's really a renaissance period for administrative law. I think we'd all agree on that. To sort of paraphrase Justice Kagan, in a sense, we are all administrative law scholars now. It's a topic that's been hard to avoid, but also incredibly interesting. We've had some groundbreaking decisions from the Supreme Court. We have other cases pending there. And as I mentioned, we have a really wonderful panel to work through some of those matters. So the format for our discussion is going to be maybe a little different than how we run some Federalist Society programs. We're going to have one speaker speak for about 5 to 7 minutes on a specific topic, and then everyone else will have about 10 minutes or so for everyone else to join in on the conversation. Then we'll move to another topic. We're going to sort of start with some issues that the Supreme Court has decided, then move to maybe some issues that are a little less settled at the court. And Professor Merrill, I think you're going to start us off with a case some of you may have heard of, Loper-Bright, and its implications.
Thank you, Judge. The Supreme Court does appear to be remaking administrative law, and in no instance more dramatically than in the Loper-Bright Enterprises versus Raimondo decision, which overruled the Chevron doctrine. To describe Chevron as a mainstay of administrative law would be a gross understatement. The case was by far the most widely cited. I think one count said it had been cited by 18,000 federal courts. It was applied by the Supreme Court itself in over 100 cases. The two-step Chevron approach to agency interpretations of law was applied by the Supreme Court in over 100 cases. So from the time of Chevron's decision in '84 up to the overruling of Chevron in 2024 in Loper-Bright, this was a kind of cornerstone of administrative law. So quite a seismic change. The proximate cause of the overruling of Chevron, I think, is quite easy to pinpoint. The proximate cause was Justice Antonin Scalia's untimely death in early 2016. And I say that because Justice Scalia was by far the most fervent proponent of Chevron on the Supreme Court throughout his entire tenure sitting there. There's some small intimations that maybe he was beginning to wonder about it before he died, but there were just intimations. His replacement, Neil Gorsuch, was a fervent opponent of Chevron. And so once Justice Gorsuch was joined by Judge Kavanaugh, who was also a Chevron skeptic, you had a majority of justices on the court who'd expressed at least some doubts about Chevron, and so Chevron's demise was at that point more or less, I think, inevitable. So for the Federalist Society, I think an interesting question would be, why did Justice Scalia, who was kind of an icon of the conservative legal movement and of certainly the Federalist Society, why was he so adamantly in favor of the Chevron doctrine? Why was he such a diehard supporter of Chevron throughout his career? If you look at his writings, his explanation, to the extent he gave one, really was that he liked Chevron because it was rule-like. And Chevron, Justice Scalia, of course, was a big proponent of rules rather than standards, and he thought Chevron was certainly, compared to the law that existed before Chevron, was a relatively rule-like doctrine. I don't think it was myself. I think it was a sort of the two-step thing had a sort of rule-like aspect, but both steps, if you will, were very much open-ended standards. The first step was, is the statute ambiguous or clear? The second step was, well, if it's ambiguous, was the agency interpretation reasonable or unreasonable? Those are both really broad standards, and so I have a little trouble thinking that Scalia, who understood this very well, was really enamored of Chevron because of its rule-like qualities. The better explanation, or the only other one I can really come up with, maybe my panelists will have some better ideas, is that Scalia joined the bench at a time when the central policy issue involving regulation was really the trade-off between the market or market-type mechanisms and command and control regulation. And Scalia was what today our progressive friends would derisively call a neoliberal. He liked the market and he liked market mechanisms. He was the editor of Regulation magazine published by the American Enterprise Institute before he went on the bench. So I think Justice Scalia thought that this trend in the 70s and 80s was a good one. And once he got on the D.C. Circuit, he looked around him and he saw all these ancient lions from the New Deal era who fervently believed in command and control regulation and were dead set against deregulation. So I think Justice Scalia saw the Chevron doctrine as a kind of both symbolically and actually useful doctrine for trying to change the locus of legal policy making from the courts, which he thought were dominated by these troglodytes in the D.C. Circuit, to agencies, which at least at that time were seen as sort of forward-thinking entities that were promoting deregulation of the transportation sector, in some other sectors like energy and also even in the environmental area. Chevron was a perfect encapsulation of this because in the Chevron case, the Supreme Court decided before Scalia was on the court, overturned a decision by Ruth Bader Ginsburg for the D.C. Circuit that rejected the use of the bubble policy by EPA, which was a sort of market mechanism trying to make regulation more efficient. Anyway, so I think that explains why Scalia, sort of at a deeper level, liked the Chevron doctrine. He thought it was a way of disciplining willful judges, particularly D.C. Circuit judges that were trying to prevent block helpful changes in regulatory policy. Times change, and by the time of the second Obama administration, a very different set of issues emerged. This is a period you will recall when Obama announced that even though he'd lost control of Congress and was no longer able to get climate change regulations passed, he was no longer able to get the DACA program, the Dreamers program, enacted into law. He announced that he had a pen and a phone, and he would try to achieve these through regulatory efforts. And so the Homeland Security Department was sort of charged with promulgating a large-scale amnesty for certain classes of immigrants as a matter of regulation. And the EPA, after the failure to enact climate legislation, started manipulating the environmental statutes in order to eventually force everybody to drive an electric car and to put coal-burning power plants out of business. And so I think the conservative legal movement saw itself in a very different climate than Scalia was in when he first started thinking about these problems in the 1980s. And they viewed the Chevron doctrine, perhaps not entirely fairly. They thought it was a sort of symbol of using the administrative state as a vehicle for sort of enacting essentially legislation without Congress buying into the legislative program. The president was sort of naming himself the legislator-in-chief, and Chevron was the vehicle by which the agencies were trying to put these programs into effect. So I think the conservative jurists and thinkers had a radically negative view of Chevron based on this particular climate in which they found themselves. Okay, so that's the amateur political science from me. In terms of legal doctrine, almost all of the justices that had something negative to say about Chevron had a different complaint. I think for Chief Justice Roberts and probably for Justice Alito, the big complaint was based on the case of City of Arlington versus FCC, where Justice Scalia got 5 votes for the proposition that Chevron should apply to determining the scope of the agency's authority. In other words, if the statute was ambiguous as to whether the agency had authority or jurisdiction over something, that the Chevron doctrine would be applied. This sent Chief Justice Roberts, along with Alito and Kennedy, ballistic. This can't possibly be right, and I think they were correct about that, and they dissented in that case. And so this conservative movement splits in 2013 in the Arlington case. The other new justices had slightly different takes on things, or in one case, an older judge. Justice Thomas did an interesting flip-flop and decided, after having been a loyal Chevron proponent for many years, he decided it was unconstitutional, either because it violated the Article III powers of the federal courts or because it represented a kind of unwarranted delegation of authority to agencies from Congress without an adequate control. Justice Gorsuch sort of joined Thomas in that constitutional critique. He also emphasized certain populist themes, interestingly enough. He thought that Chevron was an example of bias against ordinary people, as he called them, who came up against the federal bureaucracy. The federal bureaucracy would always win because of Chevron, and he felt this was a violation of basic principles of equality. Justice Kavanaugh wrote a law review article saying that Chevron was lousy because it was based on this key step. Step 1 was based on ambiguity versus clarity. And as he analyzed the situation, every judge has a different notion of what ambiguity means, and so Chevron was hopelessly unpredictable for that reason. Once Loper-Bright was before the court, Chief Justice Roberts sort of drew from all of these themes to one degree or another, except for the populist theme of Justice Gorsuch. But he packaged it in the form of a critique that Chevron violates the Administrative Procedure Act. So the key analytical aspects of Loper-Bright are to figure out what sort of judicial review was permitted before 1946 when the APA was passed, then to establish through legislative history of all things, that the APA was intended to ratify or adopt the approach to judicial review prior to 1946. And the conclusion was that since there was nothing like Chevron before 1946, Chevron violates the APA. That's the key analytics about the case. Interestingly enough, though, in the course of describing the pre-APA case law, Justice Roberts sets forth 3 ways in which courts in the future might draw upon agency interpretations in their own work. The key proposition he comes up with is that judges always have to exercise independent judgment. They always have to look for the best answer to every statutory interpretation question. But he says there are 3 ways in which you can utilize the agency's views in a constructive sort of way to decide what the best meaning of the statute is. One was he sort of ratified these older cases that say that if the agency's interpretation is long-standing and consistent, or if it was contemporaneous with the enactment of the statute, the courts can draw upon that of giving extra weight to the agency's views. The second was the Venerable Skidmore case, which had always been limited to situations where the agencies did not have legal authority, decisional authority, but Roberts sort of transforms it into a general kind of canon of interpretation, saying that if the agency's interpretation is persuasive because it's based on expertise, experience, thorough reasoning, and so forth, that the courts can also draw upon Skidmore. And finally, and perhaps most interestingly, he says that if Congress has signaled either expressly, explicitly, or implicitly that the Congress expects the agency to have a role in interpreting the statute, that the court should give weight to agencies under those circumstances. Justice Kagan wrote a dissent. As usual, Justice Kagan accused the majority of a power grab. Actually, she didn't actually use the phrase. I just looked at the opinion. She said it was grasping for power. But anyway, same idea. So Justice Kagan says we're grasping for power. What she thought was happening here was that the court was taking away interpretive authority from the agencies and transferring it to itself. So this was a form of judicial aggrandizement at the expense of the Article II agencies. I think if you read the opinion, it doesn't, the majority doesn't try to justify itself in those terms at all, maybe understandably. The opinion itself, I think, is in keeping with the theme of this conference, is trying to resurrect a notion of legislative supremacy. The various, particularly this notion that the judges are supposed to exercise independent judgment and always come up with the best interpretation of the statute, I think that is grounded in the understanding that the judges, if they're doing their job correctly, are going to try to figure out what the original public meaning of the statute was at the time it was enacted, and that's what Congress really wanted the statute to mean. And so if judges will interpret statutes that way, they're going to be reinforcing the power of Congress rather than deferring to administrative interpretations that may deviate quite a bit from what Congress anticipated originally. Also, I think this theme about Congress being empowered to signal whether it wants the agency to have an interpretive role or wants the courts to perform as a default purely interpretive role is also a signal that the court is interested in empowering Congress to be in charge of how the statutory interpretation enterprise is supposed to be conducted. So I think that if you take them at their word, what was motivating the court in Loper-Bright was really a power shift, but it was an attempt to shift power in terms of making policy away from the executive branch to the Article I legislative branch. Now, maybe practically speaking, this has the effect of empowering the judiciary because of Congress's failure to do much legislating these days. So from a realistic perspective, maybe it does empower the judiciary, but the vision of the case, the vision of the decision, I think, is one in which we're trying to get back to a world in which Congress is the primary policymaker, and in that sense to reinforce, at least in part, the original structure of the Constitution that was ratified by the framers.
Great, thank you for that summary. I don't want to necessarily call on anybody, but we can have a 5 to 10 minute sort of follow-up discussion across the panelists. Also, I saw Professor Mendelson taking the most notes, so maybe I'll start with you if you want to begin.
Sure. So, thank you for that super interesting analysis of the case. I'll just add one quick comment at this point. I mean, I think even if the kind of vision of Loper-Bright is to shift more power to Congress by honoring the statutes, I think we do have to worry that in practice it's not going to end up functioning that way, and in a couple of ways. One is the courts focus on the original public meaning of the statute and its indication that lower courts should conduct analysis in that way, I think is going to result in, more frozen statutes, even when Congress has deliberately chosen, capacious language. So, for example, in the Federal Food, Drug, and Cosmetic Act, Congress wanted the FDA to regulate drugs. I think we all agree that whatever we might think about the government generally, that having safe drugs available to the public is a valuable function. And of course, in 1938, we didn't have antihistamines and we didn't have, immunotherapy treatments for cancer. And so one concern about the kind of frozen approach the court is signaling might be the best approach in Loper-Bright is that it won't really honor a broader intent by Congress in using broad words, that these words have new applications over time. I also think there's a concern about Loper-Bright that even if Chevron was unpredictable, that in application Loper-Bright's going to be quite unpredictable. The Skidmore standard was never easy to predict how it would play out in practice, and the court seems to be doubling down on Skidmore. So I think these are both things to watch for as we move forward and as Loper-Bright gets applied in the lower courts.
Anyone else?
I'll hop in. Thank you, Tom. And I've learned tons about Chevron from reading your work. And this is a great presentation. A couple thoughts, kind of my own thoughts on the kind of the JV political science of why things changed. And I think there's always going to be multiple vectors explaining any particular event. But other things to look at possibly, or at least that kind of complicates the political picture, is you nevertheless had justices looking to overturn Chevron. The souring turn definitely occurred with Obama and the pen, but it did continue when Donald Trump had the pen and the telephone as well. And if it's if it's a kind of meta politics, it's kind of a long game meta politics, which with kind of not clear political valence, because if we're going to be if we're kind of rooting for certain regulatory sides, you think that there would be maybe a little bit more flexibility on whether to get rid of Chevron under competing regimes. And I've been thinking about for a while about other possible or additional reasons why it changed, and this is probably just kind of the occupational hazard of being a theorist, but I think changes in interpretive theory had a lot to do with it. I guess a couple two kind of changes in thinking about textualism and formalism I think went on. First, earlier on, there was the earlier idea that Chevron would kind of serve as a non-delegation proxy. That if we don't defer to the agencies, Congress will do more, and say things specifically because they'd rather not kind of share power with the president, and that just. Yeah. Oh, yeah. Overturning Chevron. Yeah. And so, Chevron would kind of. Well, Chevron could kind of serve as a kind of non-delegation doctrine, in the sense of it would incentivize Congress to speak clearly, because otherwise you'd be giving power to the president, and that just didn't happen, right? At least kind of that wasn't borne out. And I think another part of it is kind of the change in way I think textualism and formalism thought about itself. I think if you kind of read the early 80s or the 80s, early 90s scholarship about textualism, there's much more of a legal realist cast to it, that when the law runs out, it's just kind of policy choice, and there's kind of this kind of a closer kind of on-off, like they're citing Max Radin and all the legal realists, and there's a sense of yes, when law runs out, it's policy. You've got Judge Silberman writing his famous paper about the line between law and policy, and kind of embracing that. When the law runs out, it's political choice. But as interpretive formalism and textualism developed over the past 10 or 15 years, for better or worse, that kind of formalism doesn't tend to think, at least on questions of law, that things run out, that there are better or worse interpretations, at least when we're doing kind of law as opposed to policy, and kind of believing that we can draw lines between law and legal lawyers' questions and policy questions. So you could say, look, if we're in Chevron, if we're in interpretive, legal question world, we can go at what the best answer is, and what I think the best answer is, if I'm a textualist, is whatever the canons or the tools spit out, as opposed to, which could be different than my kind of policy preferences. But if we're kind of in a arbitrary and capricious world where it's just reasonableness or in the public interest or something like that, there's no lawyers' tools to operate with, so we do arbitrary and capriciousness, and maybe we'll be more willing to be deferential on that depending on what we think about the non-delegation doctrine. But I do think, at least with I think there's an increasing faith among some textualists, whether it's kind of naive or not, that you can cordon off questions of interpretation from questions of policy. And then if you kind of run through all the tools and the questions of legal interpretation, there may not be one right answer, but there may be one that's better than the other, and what you think is better than the other doesn't necessarily run on what your policy preferences are. And that may be a wrong way of thinking about legal interpretation, but if you read if you read kind of textualists in the past 10 or 15 years, there's a more legalist turn to it. And I think once you buy into that, you're less likely to buy into the Chevron framework, saying, look, when I'm not sure, I'm just making political choices within the space. And I think that might have something to do with the shift as well.
Can I respond briefly to some of these points? Nina, I agree that the unpredictability is going to go up. I'm enough of a realist to think that's inevitable. So the rap against Chevron, as it's articulated in Loper Bright, is that this ambiguity threshold is hopelessly difficult to pin down. Different judges have different ideas about what ambiguity means. Well, the court has now turned over legal interpretation to every district judge in the country. And so unless you somehow magically think that they're all going to be on the same textualist wavelength as the Supreme Court, there's going to be a lot of discord. I agree with that. I don't think there can be a simple political theory that says that the justices are going to support whoever appointed them who happens to be in power at the time. It just doesn't work. Chevron kept cruising right along with a Republican majority Supreme Court through the Clinton administration. And as you point out, it keeps cruising along at least, and then it falls apart during the Trump administration. So a crude theory would be that once Trump gets elected the first time around, the justices would all revert to being loyal Chevron advocates, but it didn't happen. On interpretive theory, I think there's something to what you're saying, but on the other hand, Justice Scalia was a kind of formalist. He believed in textualism, he believed in rules and all that sort of stuff, and bright line, black and white answers. And he was the advocate for Chevron. He was the #1 cheerleader. So I don't think there's a clear contradiction between interpretive theory and Chevron. There may be some tension. I mean, people like Gorsuch and so forth may have had some interactive effect, the interpretive thing and the hostility to Chevron, but not for Scalia.
Let me jump in for a second to make sure this could be like a game of Jeopardy where we just hit the light first and have the winner, but Professor Mascott, I think you wanted to say a couple of things.
Oh, but well, thank you. I just was going to say, it is true, obviously, that Chevron had some, I guess, virtues of through the deference, allowing there to be an easier decision in some ways. But I think the methodology itself actually had a fair amount of uncertainty at times as well, which is one reason it took, up more than 100 pages or so in a lot of ad law case books, because the court itself in some ways I think had tension in applying it, right? Is it a sufficiently formal agency document or form of action for us to apply Chevron? Is it actually a statute that the agency has jurisdiction over or has power under, or multiple agencies interpreting it? And then how does step one work? I also like Professor Merrill's point. It actually is striking that the justices first started really writing serious questions about Chevron in 2015 during the Obama years, and then stuck with it all the way through the Trump administration, and then finally found it inconsistent with the APA during the Biden administration. The one final thing is, and I think this has come up in all the comments, but that it's easy when you just hear the top level holding of Loper-Bright to think agencies don't get deference anymore, and as a lot of the comments are sort of hinting at, actually there's still a lot of deference in the policy space. It's just a matter of drawing the line between where the law runs out and where agencies have policy discretion. So it'll look a lot different, and I'll be curious to see over the years what work litigants ask the Supreme Court to do now on operationalizing what policy discretion is supposed to look like. So essentially under the APA, once the court tells us what the legal standard is, which might be broad, it might say agency make the air safe, or agency lower the mercury levels, and then what's that supposed to look like? So the APA says, just find it unlawful if it's arbitrary or capricious. And so thinking through a little bit more how tough that standard should or shouldn't be, what kind of evidence the agency has to show. There aren't a ton of clear rules of the road on that right now, and we'll see if courts are called in more on that, if the Supreme Court has to weigh in future years.
Okay, why don't we move on to our next topic, which has also been treated by the courts, sometimes very expressly, sometimes less so, and that's the major questions doctrine. Professor Pojanowski, I think you're going to take the lead here.
Thank you, Judge. I mean, first, I agree with Professor Merrill that I don't think Chevron is. Don't worry, this is about major questions. I'm not just going to take up my time. I do agree with him that I think Chevron is more about understanding what the judicial role is in the nature of interpretation as a kind of bolstering the legislature. I think it's more an idea about what the judicial role is, as opposed to a way of kind of empowering Congress. So I agree with Professor Mendelson on that as well. This is ostensibly one, whether it works or not, this is one doctrine that I think is, directly geared at, trying to, power, supercharge the impetuous vortex. That's the theme of our conference here, and it's called the major questions doctrine, and the gist of the major questions doctrine, or what we're calling it now, is the basic insight is, if it looks like an agency is trying to do something really, really big with a provision that maybe in isolation or maybe even kind of on its own seems to allow it to do that, but if you look at the broader context, suggests like there may be a slight misfit for that. There's going to be some discomfort about that. One of the kind of the impulse was Justice Scalia in the MCI case is Congress doesn't tend to hide elephants in mouse holes, right? If there's kind of this ancillary provision which is kind of vague or ambiguous, and all of a sudden, boom, the agency has a whole bunch of power. The courts are going to tend to look askance at that, and there's a common sense notion to that, and the question is how far do we take it and how do we operationalize it, right? And so one of the early kind of important cases about that goes to the Pure Food and Drug Act, right, where you had it defines a drug as a article other than food intended to affect the structure or any function of the body. And the Clinton FDA wanted to regulate cigarettes under the FDA, and nicotine is an article other than food intended to affect the structure or any function of the body. I mean, that seems, tenable. It does. The cigarette companies are certainly intending it to affect the structure and function of your body because they wanted you to buy more cigarettes, right? But if you looked at it in isolation, you've got a pretty good argument that the FDA has the power to regulate tobacco. And this case came up when Chevron was still existing, and the court looked at that not only that provision but the broader structure of the act, other tobacco legislation, the unique political history of tobacco, and said, notwithstanding this kind of individual provision, we think the broader structure of the act and the code as a whole suggests that Congress did not want the FDA to regulate tobacco. And almost as an afterthought, they said, and we are not going to give Chevron deference on this matter because we don't think it's sensible to think that Congress would delegate interpretive authority to agencies on major questions like this. If they're going to do it, we'd expect them to speak a little bit more clearly. And so cases like this trundled along for a while, and for a while the major questions doctrine, before it was kind of formulated as that, was essentially kind of a Chevron escape hatch. Whether we're deciding whether Chevron applies or whether if it applies, we're at step one, the agency loses because there's a major question and it's not plausible. The court doesn't think it's plausible to think the agency has this power, and a fortiori, we don't think Congress delegated them authority to kind of make that decision, right? And then as Professor Merrill said, Chevron died, but the major question doctrine lives and is arguably, or not arguably, is certainly stronger, right? And so the question is, what kind of canon of interpretation is it? And there's disagreement about this, I think, and I think the cases can be read in a number of different ways. One question is, one formulation, and I think Justice Alito and Justice Gorsuch like to frame it this way, it's something like a clear statement rule. So if you remember from your statutory interpretation or leg-reg classes, there are some places where Congress has to speak clearly to reach a certain result. So retroactive application of civil statutes or extraterritorial application of statutes. You can read it on its face and it looks like it should be applied extraterritorially or applied abroad. But there's an implied limitation unless Congress speaks clearly that we want it applied abroad or we want it applied retroactively. If the major questions doctrine is like that, it's a very powerful canon. So if Congress wants to do something big, they got to speak clearly about it and with particularity. Right? That's one way of understanding what the major questions doctrine is. Another may be something as kind of an ambiguity or vagueness or ambiguity or vagueness kind of tiebreaker. Maybe something like the rule of lenity. Right? If the statute's not otherwise clear. If it's a major question, we're going to err on the side of saying Congress, hasn't delegated the agency this power. A third way of understanding it, and Justice Barrett, I think, tried to in her concurrence in the Nebraska versus Biden student loans case, which may or may not, hit some people in this room powerfully. That this is just this is a way of kind of understanding ordinary meaning. We don't think, it's the way language works. We don't do big things through muffled hints, right? And so this is not a dice loading canon. This is not something like the rule of lenity. It's just the way ordinary kind of language works. If Congress is going to do something big, presumably they're going to say it with a little bit more particularity as opposed to in an et cetera clause or in an ambiguity, right? So there's debate about that. And then there's the deeper question. This is especially for especially for textualists. I mean, a lot of people who are non-textualists, who are big fans of the administrative state. This doctrine is an anathema, right? It hamstrings government in a way that's really troublesome, and could undermine what Congress meant or what Congress in fact intended. But it's also challenging for textualists, right? Because you have to ask what's the justification for this canon, right? One justification could be, and you get this a little bit from Justice Alito and Justice Gorsuch, is we're kind of protecting substantive non-delegation values, right? And if that's what's going on here, in the same way that we have substantive normative canons about extraterritoriality or retroactivity, we might say, well, what gives you the right to do that? Is this going to be is this a specific kind of substantive canon that Congress knows about and can plan around, or is this kind of this freewheeling thing that, hey, I don't like non-delegation, I'm scared to enforce the non-delegation doctrine, so I'm just going to kind of do this thing? Do you get to do that if you're a textualist, or are you starting to look like a purposivist? Are you starting to look like a dynamic interpreter? And I think Justice Barrett was very sensitive to that in her Nebraska concurrence. Her argument is like, look, this is a way of kind of understanding how ordinary meaning works. It's a good estimator of how a reasonable reader of legal English would understand these terms. And that would be a happier story if you're a textualist who likes major question doctrine. But there's going to be a challenge to that as well. And I don't think the challenge is necessarily in a pro or deregulatory valence, because you could imagine invoking the major question doctrine to radically deregulatory provisions. You can read a vague statute to require cost-benefit analysis every time you're going to do something, and that's a big major change. The major questions doctrine would not like that, right? So you can imagine it often will practically break regulation, but it could break deregulation too. But it goes to the delegation versus non-delegation. You have a backdrop assumption that Congress doesn't like to delegate. And that may be true or that may not be true. And the question is it a reasonable estimation of original meaning or legislative intent to assume that Congress doesn't want to delegate? We may not want them to delegate. We may want the imperious vortex to do more things, but sometimes Congress might. And so the question is that presumption kind of across the board a good estimation of what original meaning is? And I've talked enough, so I'll stop.
Great. Any reactions? Sure, Professor Merrill.
I'm going to go out on a limb and predict that the major questions doctrine is dead.
It's not dead.
It is dead. It's dead because the Supreme Court can do anything that it wanted to do under the major questions doctrine under Loper-Bright, using independent judgment about the meaning of statutes and invoking these canons against surprising and deviant agency interpretations. And also the major questions doctrine, if you take seriously the theory of Loper-Bright, maybe we shouldn't, it's a Roberts opinion after all, but the theory is that, the courts can't do anything that wasn't done before 1946. And you can scan the entire jurisprudence before 1946 and you won't find anything like the major questions doctrine. So the major questions doctrine violates the central legal theory of the Loper-Bright opinion.
Yeah, I think we need to hear from General Nielson.
Yeah, so I'm going to speak as Professor Nielson generally, but as General Nielson, I have litigated major questions cases very recently, as recently as Wednesday, in the Supreme Court. So, I used to be pretty skeptical of the major questions doctrine when it first was emerging, because I'm like, how can anybody possibly tell the difference between a major and a non-major question? And that seems like a real big problem for a doctrine. Then I started to teach civil procedure, and I realized we do this all the time. Remember when you took all of your cases about international shoe, and you read all of the cases, and you got a body of law, and then you could write rules, and you can kind of do it that way. So, look, I'm a believer now in the major questions doctrine. And I see cases where you need a major questions doctrine. Biolchini, Nebraska is a case that just jumps off the page. We had one earlier, I guess last year, a follow-on after they already lost Biden in Nebraska. They tried to do it again for $475 billion. And I got to argue a $475 billion case to say, like, before you can spend $500 billion, like, point to something clear in the statute before you can do that. And I think that is the kind of common sense that is driving the doctrine.
Okay. So I'll just say a huge benefit of Loper-Bright is that now we don't have to teach Chevron Step 0. For those of you who take an administrative law or legislation and regulation, it's a terrible part of the Chevron doctrine, as Professor Mascott was observing earlier. But now we have to teach the major questions doctrine, which I think is actually extremely unpredictable. We don't have objective criteria for significant economic or political impact. I think one question we actually have to consider is whether maybe at some point in the future, it will turn out that significant economic impact becomes a question of fact. And if that's true, what is the court supposed to do with lower court rulings? I want to make a second point, though. This conference is about Congress, and my concern with the major questions doctrine is for Congress. The MQD is a little bit of a gotcha game for Congress. As others have already observed, these are cases where the text is capacious enough to include the issue on the table, especially I think for West Virginia versus EPA when we're talking about a system of emissions reduction. That was the issue in the case. The court conceded, look, there's a textual basis for this, but it still wouldn't read the statute to cover the action, even though Congress could come back in and change the statute, correct the understanding if it turns out that the text was not actually what they had in mind. But the problem is that if you lose a major questions doctrine case, even if the broad language seemed to authorize the action, you've got to go back to Congress. Congress has to legislate twice to get the outcome that it wanted. And I think that's an overly heavy burden on Congress, especially if what we want to do is revive congressional deliberations and encourage them.
Okay, we have a few more topics to cover. I sort of like this dead or alive theme. So the first one under that heading, Professor Mendelson, you're going to talk about the notion of independence, independent agencies, watchdogs, and the like.
Okay, all right. Well, we'll see. So I haven't had a chance to say this yet, but I am so delighted to be included in this discussion this evening, and thank you to the Federalist Society for inviting me. I promised to keep these remarks on independence brief, so I'm actually not going to review the kind of many Supreme Court opinions that have upheld independent agency structures. Instead, I'll simply say, as everybody knows, that the court has taken a far more dubious view of independent structures, starting with the Peekaboo decision in 2010 and SELA law in 2020 dealing with the Consumer Financial Protection Bureau. So what I want to instead do is focus on where we're headed and where we might be headed. So the 1935 ruling in Humphrey's Executor upholding multi-member commission structures seems likely to be revisited very soon. The case involving Kathy Harris, the chair of the Merit Systems Protection Board, is coming up through the courts, as well as the Gwynne Wilcox case involving the National Labor Relations Board. There were district court opinions rendered in connection with both those removals in the last week, and they're clearly going to work up through the courts. The central challenge here, when we're talking about independence, at least that's the way I want to talk about it this evening, is for-cause removal restrictions. So are for-cause removal restrictions acceptable to provide, a small measure of independence, or whether instead does the Constitution require the president to have plenary, at-will removal authority for all these senior agency officials? So I want to make 2 points about this. First is the question of whether independence for officials is appropriate is really a very nuanced question. We got some flavor of this in the civil service debate earlier this evening. So it's a very nuanced question. The second point is this is a question where Congress is better equipped overall, to weigh the concerns. So on independence, there's no dispute that there has to be a core of presidential control, and there already is. When we're talking about independence in the agencies, we're really talking only about very moderate independence where we have it at all. So every executive officer and employee is already subject to supervision and firing. Even under a for-cause removal restriction, any official that abuses or neglects their authority can get fired. So what do we gain from greater presidential control through at-will removal? We get more supervision, ideally, and we hope more electoral accountability through the presidential election. But these gains are far from clear for the full array of government decisions that we're talking about. So those kinds of benefits, electoral accountability, political control, political supervision, I think are most valuable for broad and visible policy decisions. So do we set motor vehicle standards, stringently enough that as a practical matter, we're going to get a lot more EVs? I think that's a strong case for closer political supervision there and a process that engages voter views and that weighs in favor of political control. And of course, we already have at-will removal for the heads of the EPA and the Transportation Department. But for important settings, unfettered political control through the removal power has, dubious benefits, and distinct risks and greater independence can really be valuable. Lots of settings, as I say, have already come up this evening, but I especially want to focus on adjudication, enforcement, and particular decisions that implicate entities and individuals, case-specific issues. To make, I hope, a pretty straightforward point, a voter just isn't likely to choose a presidential candidate based on, the size of a penalty an agency official sought for securities fraud, or how an agency inspected worker safety at a particular factory, or whether an agency granted or denied a permit to discharge soot or denied disability benefits. And the president or presidential staff may not be well equipped to, systematically supervise decisions like this against the backdrop of the removal power. And the flip side here is there are distinct risks in these settings. There's a distinct risk of mischief from what we might call the dark side of political control, especially with cases that are likely to fly beneath the public's radar. So, of course, the classic example here of political leadership that wants to punish enemies or reward friends is, Nixon, the Nixon administration asking the IRS to conduct politically motivated tax audits. Again, that's the classic example. That kind of risk could infect other decisions, pharmaceutical approvals, broadcast license decisions, and those kinds of risks could be worsened with unfettered removal power. And these are areas where the electorate is just less well equipped to investigate or detect or kind of bring these issues out into the open, into the sunlight. Even with for-cause removal restrictions, we see criticism of some agency adjudicators. I want to call out especially the FCC and the SEC, both of which have been the subject of academic studies. The critique is these adjudicators have been too cozy with enforcement officials. Eliminating removal restrictions for adjudicators could make that kind of problem, worse. So these kinds of concerns are the reason why, for many years, we've had a bipartisan norm of independence in these settings. So the norm has been that White House staff typically won't be in contact with line enforcement officials or agency officials deciding individual cases. And that norm is the subject of, longstanding White House counsel memos and writings by Professor Adrian Vermeule. And for adjudication, of course, as came up earlier in the evening, we have a strong American commitment to independent, neutral adjudicators embodied in our Article 3 tradition. So it's bedrock that we have to have accountable agency decisions. We have to have constrained agency decisions. But rather than instituting at-will removal and getting rid of the moderate independence we have in some settings, we might sometimes be better served by other checks on agency mistakes or overreach. Those could include internal agency appeals. Those could include judicial review. All right, so all of this leads to the second point. These are complicated considerations. They are competing considerations. For the most part, Congress is where these decisions ought to be made. Congress has a lot more experience designing these institutions, gets a far broader view on their function through oversight, appropriations, deliberations. That's probably why Congress is the focus of this conference, maybe not the only reason. Congress has designed and redesigned dispute resolution regimes over the decades. I don't want to use up too much more time, but just take the way government contractor disputes are resolved. Congress has retooled that regime countless times to respond to concerns about government contractors that they be treated fairly by agency adjudicators when there are disputes about their payments and their performance. And of course, if the concern is political accountability, Congress is our most accountable institution, not just for creating programs like this, dispute resolution devices, but also for designing them, including a reasonable level of independence that helps decisions get made more appropriately. So I think, Justice Scalia has already been invoked tonight. I think this, famous language from Mistretta on delegation should be repurposed here as well, on questions of institutional design, including how to structure regimes that give people a sense that they're being treated fairly by the government, judges should rarely second-guess Congress, and I think that should go for the quite moderate assurances of independence that Congress has built into the current system.
Okay, thank you. Any reaction, responses?
So you think that making everybody an at-will employee would be too much accountability, but is giving them for-cause protection too much insulation? In my ad law seminar the other day, I made the comment, which I thought was true, that no president had ever dismissed anybody in the executive branch based under an at-will, on a for-cause removal standard. And of course, one of my smart alecky students did an internet search and came up with the fact that 2 auditors were dismissed in the 1920s in the Treasury Department under a for-cause protection. But that's not a very robust tradition. So is for-cause too much protection for these of independence, or do you think there's got to be one or the other?
I mean, I think it's a hard question to answer. The firings that we've seen in the last couple of weeks, there's been no effort to present cause, but it's not out of the question that there could have been cause. And I think this is really an effort this is an effort more to create a test case rather than really answering the question about whether for-cause protections are adequate.
Well, surely the Trump administration is not going to defend it on the ground that there was cause.
Right, so I think it's a difficult question to answer, is the point.
Well, actually, I mean, it is interesting that the courts have not really done much interpretation of cause. So it would be interesting if there were a third kind where the president directed somebody to do something and they said no, and then it's that cause. But the other thing is, I think for the rank and file, the civil service, there's another layer that sometimes we don't talk about as much, which is the Merit Systems Protection Board. So whether or not legally there's cause to dismiss somebody who's doing drugs at work or not really listening to their supervisor or not working efficiently, they have the procedural rights to be under the statutes to be able to challenge it. So procedurally, it can take a really long time. So there's a layer of an extra decision maker who's actually not squarely within the accountability supervision line of the supervisor doing the disciplining. So even if we thought cause wasn't too burdensome, that whole structure really stands to be, I think, re-examined, because it does create a big deterrent to feeling like one can adequately supervise one's employees, I think, in the federal government.
I think these are fair points. I mean, I think the point to be made here is if the MSPB process takes too long and it overly burdens the effort to remove genuinely poor-performing civil servants from the ranks, Congress needs to fix that. And the answer here shouldn't necessarily be to constitutionalize it through a ruling on separation of powers. I will say one other thing, just in answer to the point that you made about, or maybe Judge Readler, you made this point, what if the president directed an employee to take an action and they refused? The court has put down a marker on this. In Collins versus Yellen, there's dicta suggesting that if a direct order is issued to someone and they refuse to take it, that could be cause. And so it may be that for-cause protections will end up providing even greater authority to fire than some people may first have thought.
Professor Nielson?
Yeah, that's my fault. I was the court-appointed amicus in Collins, and I made that argument to try to save the agency, and instead they took it and they said, yeah, and your agency is still unconstitutional. So sorry about that. No, I think this is a really complicated area because we can conflate different things. I think that most of us, there'll be disagreements, and if you watch the podcast taping earlier, disagreements on this. But I think a lot of people think that, especially higher up, if you have somebody who just disagrees with the president, like that seems kind of strange because we elected the president. This is law. The president has the executive power vested. And there's someone who's like running the CFPB or something. I think a lot of people say, well, that doesn't seem quite right that you could be your entire term as president and never be able to control the CFPB. That doesn't seem correct. When you run on this, that's your platform, and then you can never do anything about it. So that's, I think, where the Supreme Court is. The Supreme Court's looking at a high-level question. Now, the mechanics of addressing that high-level question have implications to go way beyond that high-level question, including the adjudication stuff that we were hearing earlier today. So the question is, what do you do about that? And I have some ideas about what you can do about that, but I think it is really problematic, especially when you talk about adjudication, because they are exercising executive power. The executive power is the same executive power that applies to the head of the CFPB, so how do you sort all of that out? And I think that if we don't pay attention to some of the trickier implications and just look at the high-level stuff, we're going to miss some important things. I think we have some answers that can help with that, but you need to look at the whole thing. If you pick up one end of the stick, you pick up the other too.
I just want to make a quick point about Congress and its electoral role, and that's obviously true. And this came up with Professor Chaffetz on the podcast earlier today. So if Congress is elected, shouldn't we be deferring to them more often? And obviously, we do want Congress to have a robust role, and they are the ones that are most directly elected, particularly in the House of Representatives. But I also think it's important to think through, and this doesn't necessarily get written about a lot. I tried to start unpacking it a little bit in a piece a few years back dealing with the very, very interesting topic of 1789 customs laws. So I'm not sure that piece was that widely read, but I think there's a difference. Like, Congress has a different electoral composition, obviously, than the president, right? So it's sort of, I mean, you have to really, I guess, think about this carefully, whether it's relevant. But Congress is elected district by district, state by state. The president, obviously, through the Electoral College, is a little bit of a more national flavor. But I think those are all intentional structures by the framers. And so even though Congress, of course, we want to respect its will, to the extent that it's putting in place something that we come to understand undeniably intrudes on the executive power, and that being the ability to be able to fire a high-level person, or even if we find that the MSPB is too constraining on the hierarchical structure within a given agency, even though Congress is elected, that's then going to intrude on the will of another elected actor, the president, that's representing slightly different interests in a slightly different way than Congress. So I don't think we can just kind of conflate the whole system as always protect what the first elected body did. We do at some point have to do a little bit more theoretical work in figuring out where executive power begins and congressional power ends. And I do expect the Supreme Court to have a number of occasions in the next few years to look at this much more closely. I will say one last thing and try to echo old school Justice Thomas, where I think a lot of these questions would be much easier if the federal government were not doing as many things in the first place, and color me skeptical that we're ever going to be able to come up with a really rational understanding of the division between Congress and the executive, when at the end of the day, the federal government is just doing way more than the framers ever envisioned. And so there's going to be tension so long as that continues to be the case. So power back to the states and the people.
Okay, I think Professor Nielson, you're going to tackle our next topic to start, and that is agency expertise.
Sure. So this has come up a little bit in both the unitary executive and the deference and major questions piece. And here's the way administrative law typically works. One of the arguments you will make in favor of the agency is, well, the agency is better at this. The agency has the expertise, so we need to make sure that our doctrines reflect the fact that the agency is better at this, and they have the expertise, which is, in many cases, surely true. Agencies are better at a lot of things, but yet that argument hasn't carried a lot of punch anymore. So in Loper-Bright, that was one of the themes of Justice Kagan's dissent. Go back to Justice Breyer in the Peekaboo case. That was the theme of why we need independence for independent agencies. And it's just not doing anything right now. It's not working. The argument does not work with the current court. So why? So I'm going to tell a little bit of a story from my hypothesis, why I think that is the case. So first I'm going to start off with the major questions doctrine. Like, where did this come from? And it goes back, we heard some of it, and again, this is simplified, everything's simplified, but just kind of go with me on this one, is President Clinton gets elected, and for the first time in generations, loses the House of Representatives in 1994. And so he doesn't have Congress anymore. But President Clinton wants to do a good job. He wants to be a successful president, but he can't get legislation through. When he tries, he has to give up massive amounts in the bargaining table. See what he did with welfare. So he goes, and he has really smart people around him, including then, Professor Kagan, Elena Kagan, and they say, well, we're going to look through all of the old statutes, and we're going to find places where there's delegations, and then we're going to use them to do our current policy stuff. And I'm not making this up. You can go read Elena Kagan's article, Presidential Administration. That's what they said that they did. So they started doing this, and they found all this old kind of statutes, and then they tried to do things with it, and the court was like, well, can you do it or can you not? And then we get into some of the issues, the major questions doctrine and Chevron. Okay, well, I think something similar is happening with agency expertise. And I'm going to quote a student note. So this is, I think, one of the most important student notes ever written. This was written 1992 in the Harvard Law Review. This is why learned hand would never consult legislative history today. And it shows that student notes has been cited more than 100 times. So when you're working on that, like, there's a dream. There it is. You can write the article. But this is what the student note says. And this is why he thought the learned hand wouldn't use legislative history today. A critical problem occurs when a judge consults the legislative history to resolve an interpretive question. As soon as the judge is introduced, or more precisely, as soon as people realize the judge is listening, the records produced thereafter become corrupted. Whatever motives political actors had ex ante in making statements that incidentally became part of the record, they did not have the anti-democratic motive that they do now today to inject statements intended solely to influence the later interpretation of the statute. In particular, political actors now have great incentives to try to shape legislative history to indicate support for results that could not have won majority support in Congress. In other words, expertise has value if no one realizes that expertise has value. But once we realize that expertise has value and the courts think that expertise has value, then you're going to try to weaponize that expertise to achieve results that you couldn't otherwise have done. Otherwise, you'll lean into your expertise to try to make it more persuasive. And the person who is the expert on this in the academy is Wendy Wagner. Wendy Wagner is not a conservative. She is one of the good, great administrative law professors, and she wrote an article, this is 30 years ago, called The Science Charade in Toxic Risk Regulation, where she makes the same point. She says agencies know that courts defer to them if they're doing technical stuff, so agencies will take their policy choices and they'll embed it in technical stuff, and then that way they get the deference. And if you do that long enough, people start to figure out what's going on. And that creates a problem. Now you don't know if it's actually technical because it has to be technical, or is it technical because you want to get it through judicial review. And it's the same, I think, this mechanism of you look around, you say, well, we tried to use old statutes, and now courts aren't letting us use old statutes that say anymore. Well, now we're going to lean into expertise. And then courts start to realize, well, you're doing the same thing. It's not actually an expertise question here. It's a policy choice, and you've dressed it up in complicated jargon, but it's actually not that complicated. Now, the problem is, sometimes it is that complicated, and judges have a hard time figuring out which one is which. But if you've cried wolf too many times, judges are skeptical, and I think that is part of the problem that we have to deal with, is what do you do when there's a policy division in the country, smart people are looking for ways to make those policy gains, and judges think they're being played. And I think that is the danger we have with expertise right now, and we need to try to get that back, because there really is expertise, but I'm not quite sure how to do that. So that's my take on that one.
So in terms of the alive or dead construct, too alive, I guess?
It's dying, because you're not getting people, the courts are not giving a great deal of respect to agency expertise anymore. I think that might be for good in a lot of cases, but there's a danger that there's going to be error costs if you don't respect expertise.
Right. Yeah, Professor Pojanowski.
Oh, no, I was just making a joke.
I don't know, in for a penny, in for a pound, but okay, anybody else want to weigh in on expertise?
It's really somebody, come on.
think you're 100% correct, and I hope you have a solution.
I'm not sure that, I mean, I think the Supreme Court is kind of into this old-time religion stuff, you know, originalism, textualism, traditions and history, and when you're into that stuff as heavily as the courts are, there's no room for sort of worrying about scientific expertise or what do the scientists think and so forth. It's just, they're not in that game anymore.
Even in the world of arbitrary and capricious, though, you're not getting the same sort of respect, which really, those are just policy choices. And the agency can't say, well, we think this is the right answer, and of course, oh, well, you're regulating this really complicated thing, so you're probably right. You're going to see cases where courts are much more likely to say, well, wait a minute, is that really correct? So I agree with you on the interpretation stuff. That's the old-time religion. But what do you do when you're talking about, you know, move away from that, where it really is delegated policy choices, and they still are fairly skeptical, which you'll see in some of the cases. Again, like, you can pick the cases. There are cases out there where they invoke this is a complicated thing, not a pure statutory interpretation question, and the courts nonetheless still say,
Yeah, so I think these are really interesting points. So, I mean, in an ideal world, which we're not in, you can imagine the old time religion on the law side of kind of the law policy divide being cordoned off from like the policy world, and you can imagine the old time religion reinforcing it. So if you have a certain understanding of kind of textualism and formalism, you say like, I'm really comfortable doing lawyer stuff, right? But when I'm in kind of like, what's an adequate margin of safety, or, you know, how many parts per million of benzene, like, look, my toolkit does not work there, right? So in an ideal world, like the old time religion can reinforce you to say, hey, look, arbitrary and capricious review is arbitrary and capricious review, and could even encourage a kind of particularly light touch on arbitrary and capricious review, in the sense of like, I don't want to get in there and kind of muck it up. Now, which kind of makes Professor Nielson's point all the more poignant. If they start distrusting what's going on in the arbitrary and capricious realm, it's troublesome. On the other hand, maybe one way out of the problem would just be kind of accepting it, in the sense of like, look, if this is the world of policy choice, and we're judges who don't know, expertise, and we can't sort out good science from bad science, and this is really the realm of policy choice, and your policy choice is to actually kind of do bad science for your political ends, who are we to mess with that? That's your policy choice, and as long as you're kind of acting within the confines of the statute, we've got nothing to say about that.
I have a question for Professor Nielson or General Nielson. We don't choose your capacity. Clearly, I was just sitting here thinking. This is the sort of thing where if we're talking about, a civil case, we would have expert witnesses and the like. That's clearly something that would be quite challenging in the context of review of agency actions, which is why we do them on the record. But what about, innovations like a greater use of a special master to review an agency record, help the courts distinguish what's legitimately a technical call from what's a dressed up technical call? Would that have any potential?
Yeah, so the first article I wrote as a law professor, which I don't think anybody likes, but I like it, is in defense of formal rulemaking, which that's kind of what I thought, I'm like, boy, and this goes back to my time in practice. There were times where I know when you take a deposition of the other side's expert, like what you can get, and though you can get those admissions, and they are very important admissions as to what's really going on, and it makes a very complicated thing much cleaner because you've got them down, you've got them pinned down. There's no dancing around on that. And if you have the same experts, which often are the same experts, that are doing it for the agency on a rule, and then they're doing it in litigation about the same thing, I sure would like to be able sometimes just to sit down and see what we can get on that record. It's maybe not quite a special master, but it would certainly clarify the scope of a massive rulemaking record if you actually had some admissions.
Well, I think that gets us to Professor Mascott's dream. If we bring back formal rulemaking, definitely power will leave the federal government and go back to the states and the people.
Okay, well, it's getting late to discuss formal rulemaking, so let's move on to something a little spicier. This is a very live issue. Professor Mascott, you're going to discuss delegation.
Okay. Well, I will just try to give a bit of context, and then hopefully we'll have some juicy, spicy talk up here about delegation. But for those of you who have not yet taken admin law, or even those who have, essentially, when the court is looking at this question of delegation, it's all about when Congress enacts a statute, is there such a thing as the statute being so broad that it essentially gives no standard, no intelligible principles, the current standard, to the executive branch, such that Congress has actually delegated away its lawmaking power. I mean, almost as though Congress has said to the executive, we don't feel like doing this anymore, you go make the laws. And, it's a kind of on one hand, it takes a lot of hubris to make the constitutional claim, because you're essentially saying that when Congress has gone through bicameralism and presentment, often with the president's signature, that still nonetheless what it's done is not good enough. And it's actually delegating too much power to the executive branch. So it really requires a lot to be able to, I guess, successfully make the claim and make the argument. I think it's become a lot more salient over the years, or ones that litigants have brought a lot more in recent years, because statutes are so broad and agencies are exercising so much power that it starts to feel like agencies are actually almost making little mini new codes when they're issuing and promulgating regulations that are having a lot of impact on the American people. So from a common sense standpoint, it often feels like the executive branch or agencies are actually doing things that are binding us, that are controlling us, and it's not really Congress after all. So what has the Supreme Court said about this? Well, in the 1930s, in two cases, the Supreme Court, when FDR was in power, essentially said, yes, Congress got it wrong. These statutes were too broad. They violated the intelligible principle. But there are many statutes that have terms like in the public interest, very broad standards that the Supreme Court has declined to find violate the intelligible principle. The Supreme Court considered the question in a 2018 case. Justice Kagan, I always get this mixed. It was Kagan and not Sotomayor, right, who wrote the opinion. Made an interesting point in a case. Some folks thought this would be a successful non-delegation case because it was in a political context where it was thought maybe you would get folks on both sides of the aisle, because it was dealing with kind of the distasteful topic of sex offender registration. But Justice Kagan in the case did something interesting where she said you can't just look at the statutory provision itself and the standard, whether it be public interest or whatever. And in that case, the particular provision had actually not given the Attorney General in and of itself, right there in the provision, a standard to use for how he was supposed to decide whether to retroactively apply these reporting provisions to folks. But she looked at the rest of the statutory scheme, which any good textualist, I think, or formalist would say that you should do. So you have to look within the statutory scheme to figure out what's going on and what the standard is. And if you can find some kind of guiding principle there, then it's good enough. Litigants continue to bring challenges about delegation. Where the delegation issue is coming up mostly this term is in a related but separate question about, rather than the dividing line between Congress and the executive branch, is there an instance where Congress is giving too much power to private actors to essentially exercise governmental authority? And maybe there that's even more troubling because they don't have to take an oath to uphold the Constitution, and they haven't been authorized with any governmental power at all. It's coming up in the particular factual context of the Federal Communications Commission and the Universal Service Fund. And I don't want to get down into the nuts and bolts of predicting how the court's going to come down in that case, except just to note that when you're talking about delegating power to private actors, one thing you have to think about that's a little bit different and something that's not necessarily top of mind is the authority or the standard that the private actor is carrying out actually an exercise of governmental authority? Or are they just like researching, imposing a standard, making recommendations? So I think in this particular case, the court will not only look to whether there is guidance given for the power that's being exercised under the statute, but whether the type of power is actually, this is our expertise, we're just giving you information, now you decide, or are we definitively binding the American people and we don't even have any kind of governmental oath backing us at all. And so delegation most broadly is just a question of making sure that whoever's issuing the decision in a particular instance is the constitutional actor that was designed to do it under the constitutional scheme. When we talk about, is there a line of power that we need to enforce better between Congress and the executive, I think many folks would say, of course, yes, there is. How do we get there? Is it delegation challenges? Is it more closely interpreting statutory schemes? Is it going back and finding Commerce Clause problems? I think the Supreme Court, maybe you all, and maybe with this I'll punt it to everybody. I think maybe not in the private delegation case, but in the questions between Congress and the executive as they come up, that the Supreme Court is still a ways away from weighing in on that, because many of the justices, even on the more conservative jurisprudential side, are very uneasy with unsettling old standards like intelligible principle unless they have a new standard to come up with. And it's hard to get much more open-ended, I think, than figuring out even the Justice Gorsuch standard, right, of, well, it's a delegation problem when the agency's making the rule to bind the public. Of course that's true, but what exactly, like, does that mean, and where's the line, and how does one enforce it? And I just think it's going to be really hard to get folks like Justice Barrett to go along with that unless somebody can come up with an alternate standard or test to impose.
This universal service case is, what's it called? The name of the case?
Consumers research.
Consumers research. Yeah, I mean, there are a number of off-ramps here that might give the court the opportunity to write a juicy opinion without actually, whole hog reviving the non-delegation doctrine. I mean, there used to be some cases, I know this because a student wrote a paper about this years ago for me, that sort of disfavored subdelegation, that there had to be some kind of specific authorization for a subdelegation. So I don't know if that's true or not in the Federal Communications Act, that there was an authorization of subdelegating the authority to set these universal service fees or not, but that would be a way to tackle that. There's an interesting article written recently by a guy named Alexander Volokh at Emory, who takes the position, with some credibility, that the court has never invalidated a delegation on the ground that the delegation was to a private party. That there's some dicta to that effect, like in the Schechter Poultry case, but actually the delegation there was to the President of the United States. So there's, there may be some interest, but you could also say that private delegations, you could create that doctrine that private delegations are bad. So I think you could tackle it on the grounds that there's been no actual delegation, no actual delegation of authority to subdelegate, or there's been no actual delegation of authority to delegate to private party. And that would be a way of writing a significant opinion, but not, sort of doing what Gorsuch wanted to do in Gundy.
Yeah, I tend to agree with Professor Mascott's prediction about whether the court is going to directly take it on. I think the kind of legalist, formalist person's like, give me a rule, or give me a judicially manageable standard to work, as opposed to like too much is too much. And I think it's going to make them hesitant unless they find, it's funny, like Gundy, like you have Justice Gorsuch saying, hey, law professors, scholars, give me some tests, give us, work it out. I mean, so I think unless they kind of get something that they feel is tractable. I mean, maybe someone will get excited about Gary Lawson's like, we need to look to the 18th century agency law to understand how delegation works, and if we can, that seems kind of, if we're getting the old time religion, that might be something, I could see someone like Justice Thomas embracing or something like that. But
yeah, I think if you look at agency treatises from the early 20th century, there was this rule against subdelegation without express authority. Yeah.
But I mean, I think until they feel, at least I think until until you have a more tractable standard, I think they're going to be really scared of reviving it.
I tend to agree with all these comments that it's really hard to come up with a more tractable standard, and the court might be reluctant, as Professor Mascott says, to disturb the old doctrine unless they can really come up with something great. That said, I just wanted to give a shout out to Professor Walker, who's filed a amicus brief in this case, I think for the Chamber of Commerce, right, proposing a new standard, so maybe the court will take a look at that. On the private delegation issue, this is a tough issue. I think your student's right that that private delegation has come up in a lot of cases, but the court hasn't really directly tackled it. And in this case, they might be able to dodge it because, formal or not, the FCC did appear, I think, to exercise the final decision. But there are lots and lots of settings across the government where, to a greater or lesser degree, government action is substantially influenced by private action. And so for the court to actually open this up, I think would open up an enormous number of issues. One that is of a special interest to me is the large number of privately drafted standards that agencies adopt into, incorporation by reference, right, into federal law. That's not an issue in this particular case. It's a special issue in these other settings, which involve a whole array of things like toy safety standards and pipeline safety standards and all kinds of issues. But those are actually not available to the public. And so there are some important checks that are missing on this kind of private delegation. And I think if the court gets interested in it, it might actually want to tackle some of these issues.
Just real fast, the problem with the non-delegation doctrine is it's so hard to apply. There's a couple of ways, context that you could do it. One is really big and one is small. One is, I think, the private non-delegation doctrine. I think that's one that they could do and pretty precisely. I don't even know if it's an Article 1 problem. It's an Article 2 problem. Like, I don't understand how these people, they haven't taken an oath, they haven't been appointed, they're exercising government power. Like, what are we talking about non-delegation? They can get the first step on those ones. Correct. But the second part is the other line, which Justice Thomas has suggested, which I don't think there are 5 votes for, would be, how about we do the line between public versus private rights? And if it's a public right, sure, let them delegate, but not for private rights. That would be a huge, huge, huge change. I don't think that there are 5 votes for that yet, but that's where the court is thinking about is give us a line, and those are a couple of lines that have been thrown out there. Gary Lawson, we've mentioned him. John, you had a book called, What is the Test? And there's 12 authors, and they all had a different test. I don't think that's the helpful book. The book should be give us a test, give us the one test, and
How many you want?
12 is worse than none. So I don't know. I think that's the problem.
Okay, maybe I'll ask one question, but then we'll have some time for questions from the audience. So when we talked about the first set of cases, major questions, Loper Bright, in some ways that was the Supreme Court maybe protecting the interests of Congress and making sure that all essentially, policy isn't decided by the executive branch as opposed to Congress, Article 1. We have this great title for the program, Reviving the Impetuous Vortex. I've heard this maybe said similarly on some podcasts recently, Making Congress Great Again. But any thoughts on whether Congress will regain its footing as, sort of, I think, the first among equals across the 3 branches, which is, I think, what the framers intended and had devised? Or is that asking too much? Any predictions or thoughts on ways Congress might or can reassert its authority?
Yeah, so this is with some trepidation. But among conservatives, we generally don't like Congress to get too big because we don't like big government, and Congress is part of the government. It seems to me that if we want Congress to be able to do some of the things that we are saying that we want Congress to do, we need to make sure Congress has the tools to do it. So their staffs need to be bigger, take some of the resources from the executive branch and bring it back to the legislative branch, get bigger staffs, bring in experts, bring in the type of expertise that we want, and bring it within the legislative branch. And the initial people who will oppose that will be us. because we will say that is not what we want. We don't want a huge Congress, which I understand that instinct, and I don't really want a huge Congress either. But if we want to have the expertise to be within the federal government but not within the agencies, well, then where are you going to put it? So that would suggest that Congress needs to invest more in itself.
Yeah, I would add to that I mean, I think the Watergate reforms were a disaster because they sort of did away with the seniority system and democratized Congress and so forth, and that reduced the opportunity for people to devote their careers to being, a senator or a congressman or something like that, which would then give them some significant power and an institutional interest in resisting the erosion of Congress's prerogatives and powers. So, I mean, it was kind of, the old system was how these southern, barons who were in Congress forever had a sort of distasteful aspect to it. But actually, I think that made Congress a more effective counterweight to the other branches than what we've seen more recently, where people are in Congress for 1 or 2 terms and then they, rotate off to K Street.
I'll just add, I actually think some of the issues we've been discussing this evening are things that we really need to tackle or to a greater extent if we're concerned about leaving space for Congress. And I want to call out 2 issues in particular, the major questions doctrine and the independent agency rulings. I think in these areas, the court is expressing concern, and maybe non-delegation as well, the court is expressing concern that somehow Congress isn't deliberating in the right way. Congress should be more specific if it wants to delegate power to agencies and the like, because the court's not so sure that Congress has actually thought about issues carefully. But it might be fair to say Congress might be doing the job it wants to do. It might be delegated, it might be creating programs and asking agencies to run those programs. It certainly has plenty of other sorts of power, whether that's oversight or appropriations or weighing in on confirmation. I don't think Congress is ignoring the administrative state at all. And so one thing that might support Congress is for the courts to give Congress a little bit of extra space to take actions that maybe don't fit exactly what the courts have in mind. But that could be empowering for Congress.
Okay, are there questions from the audience? Okay, we'll start in the back here. Then we'll come up front.
First of all, thank you so much to all of you for coming. My question is, we had some discussion earlier about whether the major questions doctrine is textualist or purposivist or whether it's some mix. And I'm curious what all the panelists' views on that are, to what extent it can be justified as textualist or whether it's just kind of a compromise on the way to non-delegation. But yeah, that's my question. Thank you.
I mean, I think it's from its most defensible form. It's funny. We mentioned Gary Lawson. He's got in his casebook. There's a big discussion about whether you should have a presumption that agency adjudication is formal or informal. There's a whole bunch of tests about whether it's formal or informal. And he cites, I think, a somewhat obscure law review article that says, like, you just shouldn't have a presumption. You should just kind of read the statute and suggest whether it points towards formal or informal adjudication. And I think the best way of approaching it, and to the extent there is kind of to the extent that there may be left of the doctrine, you just kind of like ordinary interpretation, and if it seems like an elephant in a mouse hole, it probably is. There may be some context where maybe something vague suggests something big, and just kind of read it like that. I think having it as a clear statement rule is troublesome from a textualist perspective. I think Chad Scuteri has tried to make as a decent argument about how you can possibly ground in it, but I think as a kind of a textualist formalist matter, I'm not sure I'm a big fan of like presumptions one way or the other. So.
I think both.
I don't think it's textualist. I with the utmost respect for Justice Barrett, who I think took the best shot at trying to say, look, nobody understands these broad words to carry very significant authority with them. And I think probably, there hasn't been systematic evidence yet. There's been some empirical work on this, but I think probably congressional staffers and ordinary folks actually do understand broad delegations just to be broad delegations, and to that extent, they're elephants. There's not a mouse hole here, they're just an elephant. And the court acknowledges that in lots of these cases. It says, look, if you look at the text, it kind of seems like it covers it, but we've got to hesitate, we've got to look at the legislative context, we just don't think that's what they were after. That kind of move is not classic textualist, it's much closer to a purpose-based interpretation or the deployment of a substantive canon, which, clear statement canons are about saying, look, we're going to put a thumb on the scale in favor of a particular substantive result, and we want to see very specific language. I think most people would consider substantive canons to be in some tension with textualism. The best defense for them is they've been around a long time, so Congress can draft around them if they want to, but the major questions doctrine is new and it's been applied to statutes that were drafted long before it was created, so that's a tough justification for it.
And I do think part of it turns on whether you think like textualists can use the mischief rule, because it feels a lot like the mischief rule.
I mean, I just don't think the way it showed up in West Virginia versus EPA was really a ton like a substantive canon. So I kind of see it as textualist and almost somewhat tautological. Like, if the statute authorizes a big thing, it's going to be evident from the face of the statute that this is supposed to be done. And in the particular statute at issue, there was one that was enacted many decades earlier. And so I think the court was essentially saying, we understand agencies are trying to creatively operate in the statute, but this is something that Congress was not going to be seen as living and breathing in the statutory text, and we want to see authority for it in the language and structure itself.
Okay, I think we had a question here up front.
So I'm not a lawyer, so I don't know what I don't know in law, but I do have a lot of experience being investigated by agencies. And so my question is about expertise, because this has been a phenomenal panel for me, really. It's been really helpful, and it's very insightful for me. But what I noticed when I was investigating, I spent 20 years in surgery, 20 years in pathology medicine, I work in technology, and when the Federal Trade Commission came in, I could not believe the lawyers that didn't know what they were doing, that had no frame of reference on the absurdity of what they were accusing, but they didn't get cleaned on that for 8 years, so the 11th Circuit cleaned their clock. So what is there inside the system that is expertise assumptive? Is it assigned? Is it just expert until you fall on your face? I don't see anything, because everything's so sophisticated now, it's actually terrifying. And you see it in cybersecurity right now because all the regulatory apparatus has been operating for 20 years, failing everywhere.
I guess, yeah. Tom says I'm the expert on expertise, which is terrifying. But I will say this. Again, I'm speaking as Professor Nielson, but you do learn a lot of information when you're in government. A lot of people are compiling information and giving it to you that you come up all the time. And I realize I am not an expert. I'm just the appellate lawyer. I'm not even the trial lawyer. But I learn stuff from a lot of different people over a while. So there is something where people get good at things because they're hearing from a whole bunch of people. Now, in every individual case, is there expertise? No. Are they using expertise wisely? No. Sometimes they have no expertise at all because no one's thought about it, but they still think that they do. That's a problem too. But there is real expertise out there, and I think that's why it's tricky. How do we suss that out?
Okay, there's one last question over here.
Thank you. Thank you all so very much. I think that's something that we forget about often are the people that these policies affect, and I was hoping to be the only person affected by one of these agencies, but my family's farm one day had some EPA agents show up and tell us that either they were going to seize our farm or fine us money that we didn't have, and what we ended up having to do was spend money that we didn't have to build infrastructure that was beholden to what they wanted. Thank God for the great state of Texas, though, as I said earlier, I'm not from there, because they fought it, and the Farm Bureau fought it with the Waters of the United States Act. So what I think we've seen here is less Chevron deference and more like a Chevron obsequience. And so what I know is that I have the utmost faith in Congress's abilities to use agency deference as a way to avoid accountability for these policies. And so are you not worried about the application of Skidmore, if that's what's left over, that in its application it's going to lead the exact same outcomes as Chevron did previously?
Yes, we are worried about Skidmore. No one really knows exactly what Skidmore means either. So we've got this coming and going all over the place here.
I think Skidmore might give someone like you a little bit more comfort that ultimately a court needs to be persuaded that the agency position is the correct position. It does move power, interpretive power, away from the agency into the courts, and if you think that's a good thing, it should increase accountability for agency malfeasance in the courts.
Yeah, I mean, one way it might
It's not perfect.
One way it might change a little bit. Again, this would be if you're under Skidmore or kind of close to de novo. If we don't know what Skidmore means, who knows? But if you're under Chevron, if the agency asks, what can I get away with, right? What interpretation counts as reasonable? Without Chevron, you have to ask, what do you think the court's going to think the right answer is? And that's going to shift, for better or worse, shift power to lawyers within agencies, right? And it kind of changes the decision-making framework, like as opposed to can I say this is reasonable, as opposed to can I convince a court of this? And of course, that depends on how much bite Skidmore has. If Skidmore has lots of bite, we're back to Chevron land. But that at least kind of changes the decision-making framework. So some of the biggest change may not be in the courts, but it may be within the agencies themselves.
We've just heard testimony that the lawyers don't know what they're talking about either.
Okay, well, when it comes to administrative law expertise, you can't beat the five up here. So please join me in thanking them.
All right. Let's give it up one more time for our panelists. All right, not sure if this mic is on, but I'm a litigator, so I don't need a microphone to project. My name is JJ. I'm the logistics director for this year's symposium. Can we please give a round of applause for my co-director, Caleb Chadwell, who's putting together all these wonderful panels for you all this evening. All right, so I know it's late, and I know we're hungry, and some of us need a glass of wine, so I'm going to try to be very brief. I have a few important administrative things as the logistics director, or as I prefer to call myself, the director of food and fun. Not that anything that goes on in here isn't fun. It's fun. We all have our own flavor. I prefer a glass of wine and an egg roll, but that's just me. So first, I'd like to pay a little homage to Kelly and Adam, who planned the 2020 symposium that did not get to happen because of a virus originated in a communist country. This is the poster that we hang in our office, and it has been an inspiration to us every single day for making this event happen. So we are so glad to have you guys here and host y'all in Ann Arbor so that we could share this victory over the virus and the communists. Thank you to Adam and Kelly. Another shout out to Adam and Kelly, who were crucial in helping me secure these liquor licenses so that we can have that wine and beer tonight, and helping me navigate the Kafka-esque bureaucratic nightmare that is the Michigan liquor control. I have the thing. They can't do anything about it now. Okay, so let's get you fed. Let's get you drink. If you will exit through. Oh, by the way, if you're visiting us from Ohio, unfortunately, this is where your evening ends. Everyone else is welcome to the reception. There's going to be a lot of jokes at the expense of Ohio this evening. I apologize, Mr. Judge Readler. I would make a lot more jokes about Michigan State, but I don't think they were able to read the invitation to come this evening. Okay, so the bar is going to be located that way to your left. It's in room 138. It's going to be an in and out situation. We're using yellow tickets this evening. And then once you make your way across that room, there will be a wonderful display of hors d'oeuvres that we prepared for y'all this evening. We even have some Detroit-style pizza that we've secured for y'all. So, we have plenty of pizza for those of you practicing Lent. Apparently, we don't eat meat on Fridays. That's a thing, okay? There are bathrooms located in the cafe area, but they are not very large. So we do have restrooms located downstairs, but please don't wander too much or you might run into our cave troll. And we don't have coverage for that. We have a marquee. Please take pictures with it. Tag us. Use the Instagram hashtag or whatever that's called. I don't know. I'm like 32. I don't know how any of this works. But if you want to appear on our Jumbotron at the banquet, we're posting pictures there. So please take your pictures, take your chapter pictures, use the hashtag, and show up on the Jumbotron tomorrow evening. Visit our reading room. There's no food or drinks in there if you want more Hogwarts vibes. It's located in the reception area through the doors. Yes, so that is it. If you will exit through that way. Also, there is an after party at Good Time Charlie's where our chapter supposedly took Justice Scalia when he came to visit. For those of you who are not, young and spry and willing to go out after a 10 p.m. reception, there are shuttles that start running back to the designated hotels that you'll find in your program starting at 10 p.m. outside the doors just to the left of the cafe. There will be staff to guide you there. Guys, we are so excited to have y'all here this weekend. We're hoping this is the best symposium you've ever experienced. I know this is going to be the best one I've ever been to, and I've been to all three of them since I was a 1L, and I'm really, really excited to be hosting this for y'all. So, another round of applause, and then let's go have some pizza and beer.